as you said yesterday, and it is even in your file, in their file, that they are advocates on record. But they decided to clandestinely serve me direct by bringing to my official office. I would have expected the standard procedure, since I have counsels on record, to be served through my advocates. That's the expectation, but I was shocked that this is it summonses that was served, and I think you must be having a copy, that was served to my office directly, care of OCS Kilimani Police Station, for the fixing of hearing date for the above matter. They didn't even indicate the case number. As you can see, they indicated no specification. Hearing of the above matter, they didn't say, at 9 a.m. This document I received, because, Your Honor, you know, it is good to be factual. Most of us who play the game of politics, I was away. And therefore, when this service was done to me, I just came to learn just the day before coming to the court. That was, in fact, in the morning, because on 16th, that morning before we appeared before you to give us dates. And these people, you know, it is judicially aware that most of us, or politicians, are in the village soliciting for votes. So their intention was to serve me, not through my lawyers, serve me clandestinely, throw it under the door of my office in KICC, because maybe I was busy in the village campaigning and doing other stuff that relate to politics. Your Honor, I will not appear. Then a warrant of arrest is issued. Then a narrative is built that people of particular formation do not respect the rule of law. And I tend to believe that the reason...
But now I think we're just creating a narrative. Who is it that serves those summons? I believe that is not true. I want to really just finalize your argument so that they respond.
But Your Honor, I still have a quite...
It was decided that all such matters within all the courts in the Republic of Kenya need to be concluded within 4 months. From February, that comes to March, April, and May. And it was on that basis that the Honorable, the Chief Justice of the Republic of Kenya, directed all courts in the Republic to ensure that all such matters are concluded. It was on that basis that the accused person was called and told that the matter has to proceed. He was properly summoned, and we decided how to proceed. I suggested dates in April, and like he has submitted, he indicated that in April, the month of April, he's going to be heavily involved in the primaries. It was at that point that we set the dates, which are for this week, as I have another similar matter of people of other political lining, which is going to proceed next week. And since I could also not conclude all the matters before me within the fixed time, I have also allocated other matters to other courts who are also proceeding within the set time. This date was not fixed in the dark. We took into account the accused person's calendar, including his involvement in the 30 primaries that he indicated he will be busy next month. The hearing of a case is not persecution, and the one thing that the judiciary has been constantly accused of is inordinate delay of matters. This is not a fresh matter, it is for the year 2019. And therefore, as I've indicated, there is nothing special. There is nothing to show that there is any persecution. Hearing of a case is not persecution. He has not been convicted. There is nothing to show that even expediting the matter would not be good for the accused person, such that his name will be cleared even as he marches forward in his political ambitions. And therefore, for the year 2019, the accused person and his defense team have been in possession of all the documents and the matter. As I indicated yesterday, he has 4 advocates, and out of them he could have got some of them, or at least one of them, to come and represent him. And even as the prosecutor pointed out yesterday, he is an able advocate, as he has ably demonstrated in his lengthy submissions. He's not just any other Kenyan who does not understand the law. He has even mentioned that he has sat on the judiciary, on the Committee on Judiciary, and therefore he knows his rights very well, and is also able to conduct his defense well if he's so inclined. I repeat again, there's nothing special about this case. There's nothing political about the case. It is just one of the many such cases in the country that was decided would proceed because the impact on the political climate and the tone in which we should proceed as a country, so such that there is peace, and the hearing of a case is not a persecution. I therefore direct that we are going to proceed, since I was mandated to hear the matter within 4 months, and the accused person was very well aware of the dates, and if he needed counsel, he could have made all the arrangements since the day we fixed these particular dates for hearing. I will therefore not adjourn the matter. We are going to go ahead with the hearing.
Most obliged.
And when the Chief Justice directed, I thought since every Kenyan has right to information, I should be given, or even a copy, so that I read the contents of that circular, Your Honor. Because it was never even put as a gazette advert, or even provided to media, so that people who are accused, you could have gotten this information. And that is why, Your Honor, I was insisting earlier on that the way I was served and given these summonses to appear was done in a manner that was not conveniently to me. And therefore, Your Honor, on the matter of DCJ case,
You know, may I correct one impression subject to your direction? I think Honorable Cherargei needs to be very careful about what he says. Your Honor, the summons are here, and I will invite Your Honor to look at the back of the summons. They were duly served on his personal assistant. So he's busy telling falsehoods to this court, and he expects to be heard. He needs to take the court a bit more seriously.
The counsel should drop that word falsehood. Deputy Chief Justice, she is the advocate of High Court. She is a long-term practitioner of the law. But that time when she wanted to be prosecuted, the issue of her profession, or whether she has been an advocate or not, or being DCJ, was not considered. She was considered just like any other Kenyan. And the only thing I'm requesting, Your Honor, for justice to be done and to be seen to be done, is to kindly give me adequate or a few adjournment. And I've just indicated, Your Honor, that yesterday I would have objected for the prosecution not to adjourn for lack of the witnesses that they lined up to testify yesterday. But I was gracious enough. I allowed that leeway to put in place. And therefore, relying on the case of DCJ, because now that the issue of me being an advocate or not is being brought up, is that she's also a long-term practitioner. She's the administrator and sits in SCAJ. So those are
told there was that desire to have representation and not just to scatter the proceedings. I may be wrong on this. The High Court is always there to review or set aside the order by way of appeal. But for now, there will be no adjournment until a point that I'll get a stay of these proceedings from the Superior Court. I again direct that the hearing do proceed.
Most obliged, Your Honor. Could I kindly ask Your Honor that
there is a charge of incitement to violence contrary to Section 96A of the Penal Code. So that's Chapter 63 of the laws of Kenya. Your Honor, I to be unconstitutional. Your Honor, we all know that court decisions form part of our jurisprudence. And once a section has been declared by the court to be unconstitutional, it ceases to be part of our laws. And under the Criminal Procedure Code, I believe Section 89, subsection 5, you can reject a charge if you are convinced that it does not disclose an offense. So in this case, if Section 96A has been declared unconstitutional, then the court can reject a charge that has been framed based on that particular section of the law. Your Honor, there is precedent that a magistrate can invoke that particular section of the law and strike out a charge. Although you are not bound, I want you to be persuaded by the decision that was made by one of the magistrates.
Your Honor, without unnecessarily interrupting learned senior,
They insist to proceed till, by the grace of God, senior counsel appears in court
Your Honor, those matters of law,
to
because
tell
my
the court,
friend is limited
please,
to matters of law.
please.
I believe, Your Honor, sorry.
Your Honor, if I have no audience, I will down my tools. I leave the state to conduct these proceedings. I get out of court.
Kindly, the rules are clear. I wish to address the court. Your Honor, my learned friend,
Then, as I said, do I say or I don't say anything? As you record, I do not say anything. I also respect that. Do I have a right to reply? Thank you. I've said, and I want these proceedings to be there. Tomorrow we will get mutated. I want it to be on record that the prosecution has proceeded with this hearing. I'm told one witness has already proceeded and testified on a charge that the prosecution now has been declared unconstitutional is a fraud before the court. and I want that to be on record. That is a fraud before the court. If you know a section has been declared unconstitutional, as a learned counsel, you have no basis to frame charges against an accused person. And I state, Your Honor, that you cannot sever one count against the other. So the expression that you have, Your Honor, is to invoke the provisions of the Civil Procedure Code, Section 89, subsection 5, and find that there is no offences disclosed as against the accused person. As I've said, I've submitted before you a decision that has been made by this court before on a situation like what is facing before you, and I want Your Honor to look at that charge of ethnic contempt. If you remove...
Sorry, Your Honor, my line friend cannot...
Yes. And comments. Senior Counsel, Senator Mugeni, for his appearance and submissions and intervention in the matter. The court also appreciates the submissions as regards Section 96(2) of the Penal Code and petition number 430 of 2015, and also the ruling in the Johnston Mudama case, where the charge was struck out under Section 89(5) of the CPC. I, however, do not agree that the charge was fraudulently brought to court. There could be many explanations, either an error, but it cannot be said to be fraud. That preliminary objection is what the defense team ought to have raised when the plea was being taken. Even in the Johnson Mudama case, it was stated that at the earliest time, the counsel should urge the court and draw the court's attention and ask the court to strike out such charges. I point out that this matter is 2019 matter, and that issue had not been raised, and the prosecution has graciously considered and asked the court to withdraw the second count. As it relates to count number 2, the court finds that these are two separate charges, and as earlier indicated in my earlier ruling, the proceeding of a case cannot be deemed to be persecution. The outcome of any hearing has various outcomes: a withdrawal, an acquittal, a conviction, or even a court order from the Superior Court. We are at the hearing stage. No such objection was raised for over 2 years. And I therefore do not agree that the two charges cannot proceed. I'm going to allow the withdrawal of count number 2 for incitement to violence under Section 96 of the Penal Code. But I do not agree that the first count cannot stand. That is without any evidence at all. We are going to listen to the evidence, and of course, if the prosecution does not have adequate evidence to prove each and every element of the charge, then of course count 1 will collapse. I therefore stand by my earlier ruling. Part of the preliminary objection has succeeded and as considered by the state, count number 2 collapses. Count number 1, proceed with the hearing, and then it also collapse eventually. believe it is not founded on strong support.
For 2010 Constitution, if you are using your own police to try and intimidate me because you want to perpetuate an agenda that you have been given time from, then it is, I'm not distracted. I was just making a statement that you delivered a ruling just a few minutes ago. I requested for a few minutes to look at it, and Your Honor, that was only my argument. Why are you ordering a police to follow me around? And yet this is a court. I thought court is where you allow the respect everybody should be had. Yes. Your Honor, I think, Your Honor, since morning, Your Honor, you have been unless there is a pressure. 5-0. Because it looks like, and the argument has been simple, since this is an old matter, I thought it doesn't affect whether justice delivered today or yesterday or the day after. And I've indicated that justice should be done and be seen to be done. And therefore, if justice has been done to me, I have indicated that I needed adequate time to prepare. And I've just requested, even up to today in the morning, I requested for you even for 20 minutes or an hour to prepare. Because I appreciate the fact that for us to proceed in a seamless manner, we must, the justice should be seen to be done, Your Honor. And therefore, the ruling that you have just delivered should be, and I need to look at it. Because I could have an issue with that ruling that you just made. Is it and Your Honor, the fact that issue of status, the position I hold is a non-issue. All of us are equal before the law. And therefore, Your Honor, we cannot proceed this way until and unless this ruling that you have been given, and you tell a police officer to move away from me, because he's infringing on my space. I am not armed. I don't want to attack anybody. I am respecting the rule of law. What I'm fighting for is the principle of natural justice, that I should be armed. The fact that a police officer is standing to me and you are threatening that I can be thrown out is a clear indication that this is political persecution. Because why is a police officer near me? And you are saying you are restraining yourself. I think this is not the judiciary we wanted. We wanted a judiciary that works for all Kenyans, regardless regardless, Your Honor, regardless for the status that we are. Now, if you are using a courtroom to use police to intimidate us, then the judiciary should have been the last line of defense, Your Honor. And therefore, Your Honor, I'm requesting that since there is a ruling that has been delivered, and this ruling has raised critical issues, and you have said I can get the counsel. I don't know where you get that attitude or comment that I can get a counsel from. I don't know where you get it. But my own opinion is you are misguided, because you cannot say since my status I can get any counsel I want. These counsels that you are talking about, I don't know where they come from. I wish they knew where they come from, Your Honor. So, Your Honor, what I am requesting is that an adjournment. Yesterday, the prosecution adjourned. I didn't hear you directing them that they must proceed. I thought it was also in my interest that they proceeded yesterday. You have put it rightly that this matter came 2 years ago, Your Honor. I didn't hear you yesterday, unless you know justice must be seen to be done and be done. Yesterday, the prosecution withdrew 2 witnesses. Two witnesses. No, it's not. I'm not talking about political rally. You can see you are making condescending attitude statements. And I hope it is in record, because it's not a political rally. By saying yesterday prosecution decided not to bring 2 witnesses is a political rally, unless political rally has changed meaning. No, Your Honor, yesterday I'm making a very critical point that you made yesterday. Yesterday, senior counsel was to bring.
For 5 minutes, and that's the police officers will escort the honorable senator.
No, let me finish. There is no problem. They will escort me. campaign in ensuring that I'm being persecuted. And Your Honor, the police even are not supposed to be directed by you, they are supposed to be directed by the IG. So Your Honor, I respectfully say that the enmity that you have shown me since morning and since yesterday when this matter came up is very unfair, because it's like you are pushing the political persecution, Your Honor, and therefore, Your Honor.
But I thought you'd respect I'm not.
No, I'm not. Why would they block me at the door? I thought this is a public space. I thought this is not a private property. This is a public place.
No,
and if they are pushing me, Your Honor, if they are pushing me at the door with the status that you say I have, what will happen to ordinary Kenyans who want to access the courts of law? And Your Honor, I will not allow you, when I'm speaking, you have ensured that the police, Your Honor, I will not allow when you have just...
That's to be the court also. Your Honor, the accused person is of the considered view, according to him, that this court cannot impartially hear this dispute because it has made certain utterances, according to him, and certain moves, including sending him out of court, which he considers to be evidence that the court is not impartial towards him. Your Honor, he has also instructed me that his attempts at getting an advocate have become futile, and he is also of the view that this court is determined to either convict him or misunderstand him. He therefore wishes that this dispute be presented before another judicial officer so that the course of justice can be served, that you disqualify, recuse yourself from hearing it, and refer the matter to another judicial officer. That's all from my side.
Constitution is talking about right to representation. It is a sacrosanct right. This morning, again, we were before you on a different matter, when in the presence of court they said accused person requested for 10 minutes so that he can organize himself, organize his thoughts, and perhaps find alternative representation. Your Honor, the happenings at that time was follows. The advocate who was representing our client had just recused himself. And the point is, recused. He had not been fired by our client. And therefore, at that point, our client was flat-footed. Our client, therefore, should not suffer the prejudice of being abandoned in the middle of the sea by the captain. It's therefore imperative that he be given a chance to appoint advocates to represent him. And now that he has done so, which is fairly reasonable, we need time also to look at the documents. However, having been subjected to what has happened in the morning, our client is indeed not comfortable to proceed before this court. And it is not a statement of bad faith or an indictment against this court, but rather a fear which, be it real or imagined, it is a fear. To our client it is real. To this court it may seem imagined. But when there is a fear of bias, then this court is enjoined to present the said case to a different bench for purposes of its determination in a process that is not just fair, but seen to be fair. I wish to reiterate what my colleague Kubasu has noted. And indeed, I would wish to reveal to court that at that point we were short of making an application to address court as friends of court, because we could see there's an anomaly in the process in which our new client was being subjected to open hostility, being denied a chance to instruct advocates and being given facilities to defend himself. In any case, the prejudice will be suffered by our client, not the prosecution. It is on record that this matter was adjourned yesterday on Monday on the account of the prosecution. Nothing would be easier than giving our client 10 minutes, just 10 minutes. And that is one instance of open and uncompromisable bias against him. Therefore, wish to make the said application that you recuse yourself in this matter and be presented before a different bench so that justice can be done and also sin to be done. You much obliged.
Bad faith and is lacking in substance, both in law and fact. Your Honor, the Constitution, Article 50, Sub-Article 2F, clearly speaks to the conduct of an accused person before a court of law. And much as the accused seeks to benefit from the provisions of Article 50 as to fair trial, he has a reciprocal duty under the Constitution to ensure that he conducts himself in a manner that does not amount to disruption of court business and would